We would have put like
if it was a little cooler, I would do that. But considering I'm inside, I figured I would not do the turtleneck as of yet.
I'm paying homage to James Bond. Sean
Okay.
Connery.
I thought you were trying to.
No. So thank you and good morning, everyone. This is a public hearing for the Committee on Public Safety regarding bills number 200479 and 200593. And before we begin, I'd like Ms. Samantha Williams, Esquire, to read a required announcement.
Thank you, Mr. Chairman. I understand that state law currently requires that the following announcement be made at the beginning of every remote public hearing as follows. Due to the current public health emergency, City Council committees are currently meeting remotely. We are using Microsoft Teams to make these remote hearings possible. Instructions for how the public may view and offer public testimony at public hearings of council committees are included in the public hearing notices that are published in the Daily News, Inquirer, and Legal Intelligencer prior to the hearing, and can also be found on phlcouncil.com. Everyone who has been invited to the meeting today to testify should be aware that this hearing is being recorded. Because this hearing is public, participants and viewers have no reasonable expectation of privacy. By continuing to be in this meeting, you are consenting to being recorded. Additionally, prior to Councilman Jones recognizing members for questions or comments they have for witnesses, I will note for the record at this time that we will use the chat feature available in Microsoft Teams to allow members to signify that they wish to be recognized. In order to comply with the Sunshine Act, the chat feature must only be used for this purpose. Thank you.
Thank you, Ms. Williams. And will you please take attendance? And members that are present, will you indicate by saying that you're here and say a few words so that your image will appear on the monitor. Ms. Williams.
Councilmember Thomas.
Good morning, present.
Councilmember Green.
Good morning, present for today's hearing.
Councilmember Gautier.
Good morning, Mr. Chair. Good morning, Samantha. Good morning, colleagues. Happy to be here today.
Welcome.
Councilmember Gim.
Good morning, Mr. Chair. Good morning, colleagues.
Good morning.
Councilmember Brooks.
Good morning, Mr. Chair. Good morning, colleagues. I'm happy to be here today.
Good morning, Member Brooks.
Vice Chairman Johnson.
You're on mute, sir.
Good morning, Mr. Chairman. Good morning, colleagues. We are seeking justice for Sadiq Clark Harrison, a 12-year-old young boy who was murdered at his home this past weekend.
The struggle continues, Vice Chair. The struggle continues.
And Chairman Jones.
And I am present. Thank you again, Ms. Williams. And a quorum of this committee is present so that we are now officially called to order. And would you now read the titles of the bills to be considered today?
Bill number 200479, an ordinance amending Chapter 9, 3500 of the Philadelphia Code entitled Fair Criminal Record Screening Standards by amending definitions, revising restrictions, and amending and clarifying remedies, all under certain terms and conditions. And Bill number 200593, an ordinance amending Chapter 10, 2000 of the Philadelphia Code entitled Use of Three-Dimensional Printer to Manufacture Firearms to change the chapter title, to add definitions, to add additional prohibitions on use of three-dimensional printers, to impose prohibitions relating to the transfer, use, or conversion of unfinished firearms and certain equipment, the manufacture of firearms, and to prescribe additional penalties for violations of this chapter, all under certain terms and conditions.
Thank you again. Before we get started, I'd like to give myself and the author of the second bill to be considered an opportunity for opening statements, and any other members of the committee that wish to do so as well. This fair chance hiring bill, which is affectionately known as Ban the Box, is an evolution of a bill that was introduced by Member Miller in 2012. It was an opportunity to take a hard look at all of the barriers to employment that returning citizens may face, to give them an equal opportunity to rejoin the workforce in the city of Philadelphia. During 2016, after this bill was passed, we decided that we needed to take a second look at it, to update it, to make sure that it was doing its intended part, to make sure that people that were applying for jobs weren't summarily dismissed and their applications tossed into the round file or the trash can. And we went back and forth and had a number of meetings with the private sector, with the business community, with the Chamber of Commerce, to try to negotiate those changes. Those updates proved to be useful, not only to the intended members of society and our workforce, but to the business community. No, the sky did not fall. No, there weren't horrific stories of problems when it came to considering those who were returning to society. And we were able to upgrade those Ban the Box things to help to combat the fact that we are the poorest city, one of the poorest big cities in the country. So what we want to do today is to continue on that track, to take a look, to evaluate, to see how this law has been impactful, and to see if we can't continue along that course. And one of the things that we found that we had not done in the original Ban the Box legislation was include individuals that already were employed. Simply put, that if you were applying for a job, Ban the Box covered you. If you were applying for a position before you were summarily judged by your past, people were given an opportunity to be evaluated on the current merits of their application. But the person that was already employed, the person who was gainfully employed for a time, did not get that same courtesy. So when a company was purchased and that company decided to run everybody through, they found old convictions, old offenses that people had. And then they, after all of the years of successful employment, were asked to leave. These are real stories from real people, some of whom I had an opportunity to meet, some of whom you will hear from today. I have one individual who, Member Johnson will understand, was a real guy, and all of that comes with it. He had did his time, came home, and decided to be a real citizen. And he started a family. He went to work. He really changed his life. He went to work, and I won't say the company because we're not doing that today, but the company came into Pennsylvania, and that background check was done. And after close to a decade of being clean, being productive, being a real citizen, he was asked that his employment would be terminated. This had such an impact on this individual that it took everything he had and some of what I had to convince him that doing the right thing was the right thing to do. We want to try to close that oversight today with the consideration of this legislation. So I want to thank the members of the Community Legal Service Department who have been champions for this type of inclusive legislation. I also want to thank the Philadelphia Human Relations Commission, who has tirelessly defended some of these cases under the old rendition of Ban the Box. And I want to thank also the business community, who had the courage to listen and the courage to compromise on some of these bills. And in particular, the Chamber of Commerce, who all they asked was that we, as a council, do no harm. And with that, I'd like to give my co-chair an opportunity to talk about his legislation at this point, if he'd like to.
Thank you, Mr. Chairman. Well, first and foremost, thank you for putting together the schedule to hear this bill that regulates an issue which I believe is critical as we address the issue of gun violence here in the city of Philadelphia, and that's ghost guns. And so we'll have a presentation to kind of give everyone an idea of what an actual ghost gun is, but it's basically putting together a gun with different parts. And once that gun is fully functional, the gun does not have a serial number, and that gun could be used in a murder and or a crime. According to the district attorney's office, there has been 155 ghost guns that have been retrieved this year in 2020. So that's 155 guns that could have been involved in murders, shootings, and other types of violent crimes. We all know that we're fighting an uphill battle around this issue of gun violence. We are surpassing historical levels as relates to the number of homicides that are taking place here in the city of Philadelphia, 400 plus murders, 2,000 plus shootings. And so we need to do everything that we can possible and look at all the tools in our toolbox to address this issue of gun violence. So one key issue is the flowing of illegal guns in the streets of Philadelphia. So thank you very much, Chairman Jones, and thank you for the individuals who have decided to participate and offer testimony on behalf of this bill. Thank you very much.
Thank you, Member Johnson, for your continued laser-like focus on the issue of gun violence in the city of Philadelphia. Are there any other members of the committee that wish to have opening remarks? Ms. Williams?
No.
Okay, with that, can you read again the title of the first bill to be considered?
Bill number 200479, an ordinance amending Chapter 9, 3500 of the Philadelphia Code, entitled Fair Criminal Record Screening Standards, by amending definitions, revising restrictions, and amending and clarifying remedies, all under certain terms and conditions.
Thank you again. Can you now read the first panel to testify on this bill?
Sure. The first panel to testify will be Rue Landau and Brendan Lynch.
Thank you so much, and thank you for your work, first and foremost. But also, can you state your name for the record and begin your testimony?
Sure. Yep, gotcha. Good morning.
Good morning.
Good morning, Chairperson Jones and members of the Public Safety Committee. I'm Rue Landau, Executive Director of the Philadelphia Commission on Human Relations, the agency that administers and enforces the Fair Criminal Record Screening Act, known as Fair Chance Hiring, known as Ban the Box many years ago. And that's the law that ensures people with criminal records have a fair chance to gain employment. Thank you for the opportunity to testify in support of Bill 200479 today. Chairperson Jones gave a wonderful history of this bill, and I first came before you in 2011, and again in 2015, and again in 2018 to testify in support of this essential law. In fact, every few years, Chairperson Jones, and now with the fabulous Samantha Williams, pulls together our agency and a variety of stakeholders to review the effectiveness of the law to ensure we have implemented all unfair barriers for people with criminal records, enabling them to acquire the employment needed to become reestablished with their communities and contributing members of society. We appreciate the cooperation we've received from the members of the business community over the years to implement these rules so that everyone has a fair chance at employment. As a refresher, under the current Fair Chance hiring law, an employer is prohibited from running a criminal background check until after the applicant receives a conditional offer of employment. If, through a background check, an employer discovers that an applicant has a criminal history, the employer must conduct an individualized assessment of the applicant for the particular job, instead of being summarily rejected for employment. The employer may reject an applicant based on their criminal record after that assessment only if the employer can reasonably conclude that the applicant would present an unacceptable risk to the operation of the business or to coworkers or customers. A rejection must be presented to the applicant in writing with an opportunity for the applicant to respond to the determination. The proposed legislation amends the definition of employee to include independent contractors, transportation network drivers, rideshare drivers, and gig economy workers. It also expands the definition of employer to include third parties that facilitate the relationship of work for pay between two parties. While we have investigated cases against entities with these types of employment arrangements in the past, we appreciate having the parties explicitly defined in the law, so there is no question about PCHR's jurisdiction. The bill also expands the definition of employment process to include the reemployment of people, which would cover situations such as current employees who receive an internal promotion or employees who are reassessed after one company acquires another. Significantly, the bill expands how employers must handle pending criminal charges. Accusations that a person has committed a crime through informal charges, an arrest, or other information where there has not yet been a final determination on the matter. In those situations, an employer may make an inquiry or require an employee to respond to an inquiry only when the employer has reasonably reliable information to indicate the pending charge relates to the particular duties of the job. And consistent with current law, employers may only take adverse action against that employee if the offense in the pending charge presents an unacceptable risk to the operation of the business, coworkers, or customers, and that is compelled by business necessity. Employers are permitted to require employees to report pending criminal charges through a written policy detailing what offenses are reportable. Finally, the proposed legislation clarifies that employers who are required to conduct certain criminal background checks under state or federal law may only make those inquiries after a conditional offer of employment has been given to the applicant. It is important to emphasize that the current law has consistently allowed an employer to inform applicants of its intent to conduct a criminal background check after conditional offer is made, provided that its notice is concise, accurate, made in good faith, and states that any consideration of the background check will be tailored to the requirements of the job. As we know, a law is only as effective as there are practical enforcement mechanisms. The current law has penalties consistent with the Fair Practices Ordinance, including injunctive relief and payment of compensatory damages, but it has weak penalties for noncompliance, a $2,000 fine that is paid to the city, not the complainant. The proposed legislation allows for liquidated damages equal to the payment of the maximum 1 month salary of the job, not to exceed $5,000. Bill 200-479 will remove additional barriers to employment and provide assistance to people with criminal accusations or records as they obtain or maintain jobs to help them succeed and for all of us to build stronger communities and neighborhoods. The new legislation also will provide greater clarity and guidance to employers. The economic success of our city is inextricably linked to the ability of our residents with criminal accusations or records to obtain and maintain employment. Thank you for the opportunity to testify. I can answer any questions.
Thank you so much for your testimony. Is it the will of the committee that we hear both members of the panel and then begin questioning? Is that all right?
Sounds good.
All right. Okay. Thank you for your patience. State your name for the record and please begin your testimony.
Thank you. Good morning, Chairman. Can everyone hear me?
Yes.
Great. Good morning, Councilman Chairman Jones and members of the committee. My name is Brendan Lynch. I'm an attorney with the Employment Unit at Community Legal Services, and I'm here today to testify in favor of the amendment to strengthen the Ban the Box ordinance. I've been an attorney at the Employment Unit at CLS for 14 years, and through my work, I've had a chance to observe the impact of the ordinance since it was first introduced. And we do feel that it's had an enormous impact on the ability of Philadelphians with criminal records to obtain employment by restricting what employers are permitted to ask about and to consider during the course of a job application. And in fact, my office has used the ordinance to successfully advocate on behalf of many individuals whose records were old or minor, but were still creating a barrier to employment. During the past 9 years, however, it's also become evident that the ordinance has certain areas in which it could be is open to interpretation as being ambiguous, or where it leaves loopholes that make it less strong than it could be. And so I'm urging council to adopt this amendment, which will strengthen and improve Ban the Box in a few particular ways that especially concerns our office. Number one, it's been a long-standing issue that, as Chairman Jones mentioned, the current text of the ordinance protects applicants, not current employees. The restrictions in the law apply to prospective employers. Pennsylvania courts have read a similar state statute, a very under-enforced and not very widely known statute, very literally. And that statute likewise does not by its terms apply to current employees, and courts have consistently said that therefore it does not. And so the law's protections don't cover current employees due to the lack of explicit inclusion. It is actually not uncommon for longtime employees to lose jobs due to old criminal records, either because their employers were taken over by new companies or because they were considered for promotion and new background checks were done. And in particular, the expanded background checks that are now required under the Pennsylvania Child Protective Services law have placed the jobs of many longtime employees at risk, even though they would be eligible to remain employed if the protections of Ban the Box applied to them. However, because Ban the Box only applies to applicants, current employees effectively have no protection or remedy under state or local law. So just as an example, under the current text of the ordinance, an applicant cannot be denied a job based on a conviction or a period of incarceration, which is more than 7 years in the past. But if a person who has a decade-old conviction is offered the job and begins work, since they can't be denied it on the basis of that decade-old conviction, and then a new background check were done 6 months or a year later, perhaps because another company bought out that smaller company, or because the state law perhaps required that a new background check be done, the ordinance would no longer protect that worker from being fired on the basis of that conviction, even though it couldn't have been used to rescind the job offer in the first place. And that loophole seems illogical and counterintuitive, particularly since the fact that people got hired and then demonstrated that they were effective and safe employees who did not pose a risk, that their continued employment has demonstrated that, they would seem the people most likely to deserve fair consideration without regard to their record. But nevertheless, CLS does regularly see Philadelphians who have in fact lost their jobs in this situation, although typically they would have been able to keep their jobs if Ban the Box clearly applied and protected them. And the proposed amendment would close this loophole by adding language that would explicitly declare that current employees are covered just as well as applicants. The second big change I wanted to mention was broadening the definition of employer and employment opportunities. As most of us are aware, the employment landscape has changed a lot in the last 9 years, and many more workers, including here in Philadelphia, are now classified as independent contractors. And gig work, such as ride shares and online TaskRabbit work, has increasingly replaced or complemented traditional employment. At the same time, technology has facilitated the increase of online employment connectors and facilitators. The Ban the Box ordinance does not explicitly state whether or not gig work is covered under the definition of employment. And in fact, we would argue that there's good reason that it could be interpreted to cover those jobs. But the lack of explicit inclusion leaves room for many employers and employment facilitators to argue for their interpretation of the ordinance. And CLS has dealt with gig economy employers who argue that the ordinance does not apply to them, and so they claim they are free to deny work to people even with old or minor records. There's also the increasing problem that the work of screening the records of potential employees is being outsourced to online employment facilitators such as care.com. And this can be a way of evading responsibility for conforming to legal requirements that apply to background checks. The online facilitator will simply decline to refer a worker to a given job as a result of their record, while the employers can disclaim any knowledge or responsibility. I think it is entirely appropriate to include these employers. I would mention that the ban the box currently covers employment agencies, and it specifies that includes job placement and referral agencies. So when there is an entity that could be viewed as a third party that is involved in making a referral of a worker, and that third party is conducting the background check, the intent of ban the box all along has been to cover those types of entities. But online connectors and facilitators such as care.com, as well as gig economy employers, sometimes try to evade legal scrutiny by claiming that they do not meet the definition of an employment agency. But the essence of the issue that Ban the Box is trying to address is that when there is an entity that is able to use its power to review a job seeker's record and to potentially exclude that job seeker from work based on that record, those entities, those gig economy employers, those connectors and facilitators should be covered by the law in order to ensure that fair standards are being applied whenever a person's record could be a barrier to employment. I thought I would mention briefly that there was a big story in yesterday's Philadelphia Inquirer, and I learned that Councilmember Green had a small business in the city of Philadelphia. And I think it's worth noting that after the 2015 amendments, council members, a business the size of Councilmember Green's business would have been covered by Ban the Box. It would have been required to abide by it. Even if I didn't say how many employees Councilmember Green had, but even if you only had one, you would have been required to follow the law. But giant national corporations operating in the city of Philadelphia are arguing that they're not covered by the law. And so part of what we're getting at here is that there ought to be a level playing field, and people who are involved in employment decisions, whether it's a small business or whether it's a national corporation, should follow this, just like all businesses who act as employers have been following it for 9 years, and we have heard no complaints and no problems with the enforcement of the law. So we urge City Council to adopt this amendment, which would clarify explicitly that gig workers and those in less traditional employment relationships are covered, including independent contractors, as well as online employment connectors and facilitators. I would note that federal and state law have been especially slow to adopt to changes in the nature of employment. The state statute that I referred to earlier, it was either in 1980 or 1982. It's at least 38 years old, and it has not been amended to address the gig economy at all. I'm not even aware of any proposals to do that in Harrisburg. So the amended Ban the Box will hopefully be the one clear source of protection in many of the jobs that an increasing number of Philadelphians seek to perform. The third point I wanted to address is the issue of liquidator damages. To the greatest extent possible, the ordinance should provide for the party who suffered the harm to be fully compensated. The Ban the Box ordinance, quite properly, defines a violation of the ordinance as a matter of discrimination. And it is fitting that damages should be paid to the party who has been the victim of discrimination, as is commonly done in court cases. It's also important that we provide an incentive for people to bring these complaints so that violations of the law will be brought to light. It will often be the case that a person who brings a complaint will have no real hope of finding work with the potential employer that has just rejected or terminated him or her, since the relationship is now poisoned and the employer, frankly, has likely moved on and hired a different worker. Particularly for the low-income Philadelphians who are served by my organization, CLS, who have little or no assets and live paycheck to paycheck, their need to focus on quickly finding another source of income commonly outweighs their ability to pursue an administrative complaint at their leisure. Since they cannot get or keep the job that they wanted before their record got in the way, the only compensation they can receive is an award of damages by the commission or if the case goes to court, possibly damages awarded by the court. But if those damages are too low, there simply may not be enough incentive to file a complaint in the first place, or to put their full energy and time into working with the commission to complete the administrative process. The ordinance does currently provide, as Ms. Landau mentioned, for the complainant to receive compensatory damages, but the truth is compensatory damages can be difficult to calculate and are often quite small, especially in a situation where the applicant, having no other choice, immediately moves on to find another entry-level, low-paying job. And the truth is that when damages amount to slightly above the minimum wage for a fairly brief period of time, it may not provide a significant disincentive to employers. If violating the law can easily be borne as a cost of doing business, there's going to be much less disincentive for breaking the law. But our main concern being that the victims themselves should be incentivized to bring these complaints, and it should be made worth their time and their effort to bring these complaints. The proposed amendment would deal with these concerns by creating a new category of liquidated damages, which could be provided directly to the complainant in addition to compensatory damages. And this would increase the chance that a complainant, as a victim of discrimination, will receive a meaningful measure of compensation. For all those reasons, we support this amendment, and I thank you for your attention to this issue, and I'd be happy to answer any questions.
Well, first and foremost, thank you both for your participation in the drafting and implementation, as importantly, of past legislation that we in the city of Philadelphia have. For those non-millennials, can you do a brief definition of gig worker and independent contractor as we shift away from factory workers to this new gig economy? Can you define for those in the listening audience what those definitions are?
Point of information, Mr. Chair.
Yes.
I'm what's called a seasoned millennial, so thank you.
That's a lot of seasoning, sir. And I stand corrected. Can you give us a definition, please?
This is new enough that I think if you were to talk about the law and what does the law say, it's slightly unsettled. There is no one definition set out in the law of Pennsylvania or of Philadelphia exactly what a gig economy worker is. But the general principle of independent contractors, and as they're viewed by the entities that employ them, the gig workers, is that they are people who are not entitled to the various protections that have traditionally been connected to employment, like permanent full-time employment with an employer in the United States. And there are many aspects of law in terms of your benefits, often in terms of your rights to such things as leave under the Americans with Disabilities Act, various other protections that have been enacted to protect workers. They are often connected to the status of your employment, and they are tied to whether or not you are considered an employee as opposed to an independent contractor. An independent contractor is supposed to be someone really who has their own separate business and agrees contractually to temporarily do work with a separate entity. Our view is that this is often a fiction and an excuse for declining to provide protections, frankly, declining to pay taxes, including workers' compensation and unemployment insurance taxes. But the employers often say that it gives them flexibility, and they would say that the workers also get the flexibility of not being tied to a particular company.
So we are literally writing this area of law as we build the ship. I mean, there's no precedent for this. We are actually making precedent.
I think that we are. The law is, I think in the United States, people who are concerned about the rights and interests of gig workers are scrambling to push for adjustments to the law at various levels, federal, state, and local. And there are efforts at various levels around the country. but we are certainly on the cutting edge. But I don't think we're rushing ahead. I think the other levels of government are trailing behind because people have now been doing this work for years in Philadelphia. And it's absolutely time, and not in any way is it early to be granting them, extending protections to them. I think it's high time that we extend protections.
Thank you so much. You guys have been representing those people who feel aggrieved by these types of case violations. Give me a sense of the volume and then the rulings that we've gotten on these laws heretofore. Drew?
Do you mind if I ask CLS first and then we answer? Because I think we see a fraction of the cases that they accept.
Okay.
Chairman Jones, we have always assumed in all of our work, and CLS has been in, helping low-income Philadelphians since 1966. Since before my birth, I think CLS has assumed that we see a fraction of the problems out there. When folks come into us, they are a small representative of what is a larger problem, because we know that not everyone comes into us. And to be honest, we wouldn't have the resources to help every single person, even if they did. Although we would, much as we would like to. I would say that we certainly see probably dozens of these cases each year, and they pop up in different fields. There are some very well-known rideshare companies that I think are often I won't name them, but in public discussion kind of cited to sort of stand in for the gig economy employers, but there are many. We learn about new ones. Through our work, people come to us and tell us they got hired at some company we've never heard of. It turns out it was founded in California just last year. There seem to be new companies all the time that are following this model. And I would say that we see, in terms of your question and the numbers, I would say that we see, probably a few dozen each year.
Yeah, Chair Jones, if I could just add to this. First of all, it is imperative that City Council and the city continue to look in this area. This is exactly what's happening. It is consistently evolving. We've had many cases against rideshare companies, but it is true, and other types of gig economy workers, but it is absolutely true that it is evolving in real time. These are, so for the non-millennials, so they can understand the whole concept of even applying for a job now, you basically can apply on your phone. You're requesting access to work off of their platform. That is what it is now. You want to work off their platform. Once you get approved to work on the platform, they start to send you clients, basically, or jobs, basically. So if you wanted to drive for a company that is doing deliveries, you are applying online. They are making sure that you're approved, and they are running background checks, which is why we have to make sure we know when the background check is happening. And then they'll approve you, and then you're on it. And I'm sure there's some version of training. I'm not sure I know about that part. But the next thing you know, you're getting jobs, and you start to deliver. You start to do the work. You start to do everything. You can do it when you want to. Brendan's absolutely right. Employees like that they get the flexibility. Employers like to have a huge group of people who are willing to do this work for them. And this is all about, Americans' convenience of life, and especially helpful during the pandemic, of folks who are coming to your door, delivering things, helping you out with stuff. It is going to continue to morph. And as it has continued to morph, the largest employers have really, really worked hard to try to call these folks independent contractors. They're working on their own. We're just helping them out by giving them jobs, instead of the fact that they are employees. They are entitled to protections and to benefits in whatever degree possible. And we in Philadelphia have to make sure that we're ahead of this and that we're making sure that we're protecting them.
Thank you so much. Are there any questions from members of the committee?
There are no questions in the chat box, or no requests for questions.
Well, thank you so very much for your testimony. Please stick around for the next panel.
Yes. Thank you.
Thank you for having me.
Ms. Williams, who's our next panel to testify?
Councilman, there are no other witnesses on this bill. If you'd like to move to the next bill, there's one other witness.
Okay, so can you restate the title of the next bill?
Sure. Bill number 200593, an ordinance amending Chapter 10, 2000 of the Philadelphia Code entitled Use of Three-Dimensional Printer to Manufacture Firearms, to change the chapter title, to add definitions, to add additional prohibitions on the use of three-dimensional printers, to impose prohibitions relating to the transfer, use, or conversion of unfinished firearms and certain equipment, the manufacture of firearms, and to prescribe additional penalties for violations under this chapter, all under certain terms and conditions.
Thank you again. Member Johnson, you want to say anything or?
Yeah, I'm going to be brief, Mr. Chairman.
Please.
Because I know this is always a sensitive issue when it comes to firearms and people's right to bear arms. So I just want to clarify and give a quick summary of what this bill is all about before we have the presentation. And so, one, it will require federal manufacturers or dealer license to buy or sell an unfinished frame or receiver. Two, require federal manufacturers or dealer license to buy or sell equipment especially designed to convert unfinished frames or receivers into functioning firearms. And three, require federal firearms manufacturers license to convert unfinished frames or receivers into functioning firearms. If not, the penalty includes fines and up to 90 days in prison. And again, this all goes toward buying parts of a gun, putting that gun together, and using that gun, excuse me, and the gun does not have a serial number. And these are the types of guns that are being used right now in some of the gun violence that we're seeing. And so with that being said, I'm going to ask for Joe Shue to cue up the video before you call our first panel. And then just to give everyone just a real good overview of what these ghost guns are really look like and what they're all about. And I want to be clear and mention this again. In 2020, we have taken 155 ghost guns off the streets of Philadelphia. So this is a very, very real issue. With that being said, I'm going to turn it over to Joe Shue Harris.
Mr. Harris, state your name for the record.
Chairman, I'm just playing a video at the councilman's request.
Oh, okay. All right.
Is the video visible on the screen?
Yes.
So I'll get in here. And usually this... The Constitution allows, and the Gun Control Act allows, for Americans to manufacture their own firearm for their personal use. And that's the key, personal use. Firearm is located where the trigger mechanism is, where the components are that allows the weapon to fire. So that is the part that's important to law enforcement. We consider the firearm to be the lower receiver where the trigger housing group and its components are located. The upper receiver, which is this, the barrel and the associated, the bolt, those are not regulated. And you'll see here that it looks like a firearm from here. Yeah. It's got a magazine well, but it's got no holes drilled for parts, and this center area is solid. This is where the guts of the firearm, for lack of a better term, are located. This is where the hammer is at, the spring. The trigger mechanisms go into this piece. The solid portion has not been machined. It is not a firearm, right? This, you can see now, has been machined. Right here. Yep. All and carved out. Anytime when you start that process, it becomes a firearm. So I'll get in here. And usually this is only finger strength. There it goes. you have a functional rifle at this point. The vast majority of firearms we can trace to the initial purchaser, and that helps us identify. Sometimes it comes to the perpetrator, to a friend or family member, and we're able to help further our criminal investigations like that. When you lose that ability, that's a significant leg of the investigative stool that is cut out from underneath.
Judge Shu, is there any other parts of the presentation before we call the first panel?
Councilman, you do have a few photos as well of actual ghost guns that were recovered from crime scenes, if you'd like me to display those now.
Yeah, can you please? Mr. Chairman, can you pay attention to the photo?
Yes, Member Johnson.
Councilman, I also have a photo of a mill that is specially designed to convert unfinished frames and receivers into functioning firearms, if you'd like me to display that as well.
Please.
Can you show Mr. Chairman that prior gun as well, the red one?
Yes, sir.
I'm only pushing on him because I know we call each other every time we see that homicide in one of our districts to become a support system for one another as we're dealing with this gun violence.
Mr. Chair, I have a point of information.
Absolutely, Mr. Green.
Were these ghost guns recently acquired by the Philadelphia Police Department, and were they actually used in actual homicides?
These pictures are just examples of what ghost guns look like. Okay. So these aren't official Philadelphia Police Department ghost guns. No, not at all.
Okay, thank you.
But just for the record, as mentioned before, we have collected 155.
155, right. Okay, thank you.
For 2020. You're welcome.
Thank you.
So, Member Johnson, to follow up on Member Green's question, how many were used in the commission of a crime?
When we get into the testimony from our panel, we can get into the details of how many were actually used.
Okay.
I'll leave that to the experts.
All right. That's fair.
Thank you. To the last picture, and then we'll call on the first panel. And this is a 3D printer. And so about a year or 2 years ago, I introduced legislation around regulating 3D printer ghost guns, right? And this is basically a gun that you can put together that's plastic. You can get on airplane. It's evasive from metal detectors. And so this is what illegal guns are going to look like as we embark upon the future of addressing not only gun violence, but in some cases even terrorism. Because if you have guns that can't be detected by metal detectors, then you can use those types of guns to get involved in all types of violent crimes.
Councilman, with apologies, even though this is similar in appearance to a 3D printer, the photo being displayed right now is a special mill that's used to drill ghost gun parts, like shown in the video, to convert them to functioning firearms.
Well, that's why you're the expert. So,
Mr. Chair, I have another point of information.
Yes.
Recognizing Member Green.
Yes. Councilmember Johnson and Mr. Harris. So is it correct that you have is any 3D printer able to create a ghost gun? And then do you need this type of mill to make it functioning?
I'm gonna let Lieutenant. Go ahead, Joe Shoe.
Captain Healy's been promoted to inspector, Councilman.
I'll let the inspector get into the details.
Okay.
That's why we asked them to come to be the expert witnesses.
Okay.
So with that being said, we'll go right into, Mr. Chairman, can you call the first panel, please?
Can you give me a second?
Yes.
I have a couple of points of information. Number one, of greater concern than the actual mechanism to build the parts is the fact that anybody can go on the internet and get instructions as to how. That is as concerning as having the ability to manufacture the parts. You can get instructions. We had to take a hard look at whether or not some of our colleges and universities actually have these 3D printers. And they have legitimate purposes and are going to be used more in the future than ever. But the problem side of this, as you have noted, Member Johnson, is that, a hammer in one person's hand can build a house, and a hammer in another person's hand can bludgeon you and take advantage of your wallet. So we have to be careful on how these things are promoted in our communities, and then instructions on how to create weapons have to be monitored. So this is a very important issue, Member Johnson. All right, and with that, are there any questions of members of the panel for right now? If not, we will proceed to the first panel to testify. Seeing none, Samantha Williams, will you please name the first panel to testify?
Inspector Francis Healy.
Hi, Inspector. Good seeing you again.
Good morning, Chairman Jones and other members of the Committee of Public Safety. As you know, my name is Fran Healy, and I'm a Special Advisor to the Police Commissioner Outlaw. On her behalf, I would first like to thank you for giving the Police Department an opportunity to voice its opinion on Bill number 200593, which would prohibit the unlawful manufacturing of firearms. As you may be aware, I testified in support of current Section 10-2000 regarding the production of three-dimensional firearms, which this bill would amend. At that time, the Police Department supported the prohibition of three-dimensional firearms based upon the fact that they are untraceable, or commonly referred to as ghost guns. However, three-dimensional firearms are not the only ghost guns available, so the department appreciates that this body has recognized this fact and has made necessary amendments. Federal law requires the serial numbering of completed firearm frames or receivers. A way to avoid this requirement is to not fully finish or machine the frame or receiver. According to federal law, an uncompleted frame or receiver, as you saw in the video, is nothing more than a piece of metal. However, in a skilled or even semi-skilled machinist's hands can often complete the milling necessary to make the frame or receiver functional. So once this firearm is fully assembled, it will bear no serial numbers. You would not be able to tell the difference from a ghost gun from a lawful firearm by simply looking at it. Once it's clear that the firearm has never had a serial number is the only time you'll discover that it is in fact a ghost gun. This issue is growing. While we have not recovered any three-dimensional firearms or guns as to date, the number of ghost guns recovered has increased over the years. In 2018, the PPD recovered 12. In 2019, the number rose to 97. And year to date, according to Forensic Science Director Garvey, as of Friday, we had recovered 168. For this reason, the PPD fully supports this bill, further amending City Code 10-2000, and I'd be happy to answer any questions at this point.
Inspector Healy, are these guns made of a hard polymer, plastic?
No, I just want to distinguish between the two. A ghost gun is by definition a gun that just does not have a serial number. Now, there's two ways for that to happen. The three-dimensional process is the process of creating basically a plastic gun where they insert the springs, firing pins to make it work. That is a ghost gun, but it's a plastic gun for all intents and purposes. The viability, a lot of those guns are tenuous at best. A lot of times with the pressure, they may or may not work. The other way to make a ghost gun is to make basically a legitimate real gun. It's a metal firearm. You would not be able to tell the difference if you pick it up from one from the other. And what it's done is it's just been completed by an individual rather than a company or a firm that manufactures guns regularly. Now, as the video mentioned, it's not unlawful for people to actually create their own firearms, but it's for personal use. It's when those firearms start finding their way into the market that we see, it becomes a problem. And the biggest issue for the department is the serial numbers. It may sound a little silly, but obviously the owners are often not the people committing the crimes with these guns, but it is the first step, as the ATF agent mentioned, in getting back to where these firearms went to. A lot of times the owners will say, listen, I transferred it to somebody here, there, or the other place, and it gives our investigators the first legs towards finding the actual offender. So when we're missing that information, it does take that valuable step away from the investigative process. So, like I said, but the issue of these guns, there's two different. Like I said, the plastic guns are very different than these are real, metal firearms. They're just basically a piece of metal that's been, let's say, 80% completed, but there's a solid piece that's not finished, and a machinist basically bores out and makes the proper cuts in the metal, and ultimately makes what looks like and is an actual firearm.
Focusing on the plastic firearms, you said their durability is questionable, meaning that they may work once, twice, overheat, things like that make them a little more. Okay. So the second question I have on that is, can they get past metal detectors?
The plastic, yes, could pass, but they do require some metal parts for them to work. Metal firing pins and springs cannot all be plastic. So the frame and the receiver are made out of plastic, but oftentimes they still require some metal parts inside. But for the most part, yes, they probably could get through some type of security system, yes.
Member Johnson, you have any questions?
No, not at the moment, but I do think for the clarity regarding the ghost guns and also the putting together of guns with various parts, which we have seen, again, significantly. And I remember speaking to, he's now Deputy Commissioner Dales, when he was with the inspector. I remember seeing a picture of some of the guns that have been recovered. And this is really real artillery that's being used in the streets of Philadelphia. And so thank you for taking time out of your schedule and being here and speaking to this legislation.
One last question, Inspector. That first picture we saw, I think it had the red muzzle flash.
Yes.
What was the magazine capacity of that particular firearm?
Well, sir, the magazine the guns don't necessarily have a magazine capacity. I could put a 5-round magazine in there, or I could put a 60-round magazine there. The firearm itself does not have the capacity. It's actually the magazines themselves. So if you'll notice the port where you insert the magazine, it could be a small magazine or it could be incredibly large. So the firearms.
So that's adaptable to whatever the owner's choice is.
Correct.
Got it. And did it have a stop on it, or was it?
No, that was an upper part of a receiver. That was a partial part. That was a part of a firearm. That wasn't a complete firearm.
Okay, got it. All right. Ms. Williams, are there other questions from members of the committee?
Councilmember Green.
Member Green?
Thank you, Mr. Chair. Thank you, Inspector Healy, for your testimony. I just have a few follow-up questions that I started to raise with Councilmember Johnson. For the 3D printers, correct me, I'm gonna make sure I have a full understanding. The 3D printer can create the plastic portion of a ghost gun, but then you still would need additional millwork to make it fully operational. Is that correct?
Well, you need additional parts. The frame and the receiver would be made of plastic, but you would still need some of the
metal
spring, right? Trigger action springs and stuff like that for it to actually function.
Right. And so you would so if someone wanted to make a ghost gun in their own home that was using a 3D printer, they would need both the 3D printer for the plastic portion, but then also the additional parts to do the millwork to make it fully operational.
Correct. I just think I don't think they use the term milling in the 3D process. That's more of a metal work. Yeah. The issue is the 3D would actually be designed for the smaller parts to fit into it.
Right. Now, are you also knowledgeable from your perspective, or from others, where certain manufacturers are now starting to advertise the ability to purchase instructions or other information on how to create and assemble these type of ghost guns? Is this something? I guess my basic question is this where the gun manufacturing industry is going to promote more and more 3D printing and kits for people to create their own guns at home?
I'm not personally aware of that, just from my own experience. So the gun manufacturers will be losing business for them to be doing this. The issue is a lot of this, quite frankly, is when it's done at the personal level, it's more of a hobby issue for a lot of folks.
Right.
And they're not interested in taking the guns or selling them. That's why it's not illegal to do so at the federal level. It's this issue when people are taking advantage of that, basically that loophole, I gather, that you can create a firearm for yourself, but these folks are creating them for distribution, which is illegal.
Right. And maybe I misspoke, not so much gun manufacturers, because I think you're definitely correct in reference to lost revenue there. And I'm talking other entities who see this as an opportunity, either those in the plastics industry or others who are trying to help promote additional home gun production, just like there's been an increase over the past number of years in reference to home brewing. Of course, these are totally different, but the whole concept of, are there entities that are helping to promote more and more people to create their own guns at home? And are there additional equipment that allow people to create more than one gun at a time, to almost mass produce for their quote unquote home use of these type of ghost guns?
Well, to answer the question, quite honestly, I'm not directly aware of any entity, but it's common knowledge on the internet. You can actually create and make anything. Like I said, it's legal to make the gun. As for the equipment, I mean, it doesn't necessarily mean to have specialized equipment. If you're a talented machinist and you have, all the proper equipment for making anything else, you could probably still make you could still drill the firearms out and bore them out. They're basics. The firearms are, they come from a solid piece of steel or aluminum in some cases, and they're just bored out. And actually, there's computer programs that actually mill it all out. But that same piece of equipment could be used for, doing car rotors and stuff like that.
Right.
It's not specifically designed for this. It's just you put in the proper specifications, and the machine will cut whatever it's intended to cut.
Okay. Thank you, Mr. Chair.
Thank you. I think one of the things that the inspector talked about is the serial numbers that need to be applied to the firearms so that there is a ability to register and trace their use. So that's an important part of this particular legislation.
I have a question, Mr. Chairman.
I think Member Brooks, can we recognize her and then we'll come back to you?
Absolutely.
Thank you, Mr. Chair. I have a question about what are the demographics of the people that have previously, or you have previously collected the ghost guns from under this ordinance?
I don't have that data automatically available. A lot of these guns may have been recovered from the street or from a scene, and not knowing actually who the demographic of the individual that possessed it. I'd have to go through each of the reports to see whether or not they were recovered from an individual, or we call it recover from the highway. We found it on the highway or somebody threw it.
Okay. So what I'm trying to figure out is that under this legislation, is there a way to enforce, if you're able to track this information, some consequences for the makers and the distributors of these guns? Because if they're being confiscated off the streets, there aren't a whole bunch of people in the streets with the milling capacity in their basement. So I'm trying to figure out, is there a way, if we were able to trace it to a homegrown manufacturer or whatever in the yard or wherever they're making them at, is there a way to prosecute the maker as well as the user?
I believe that's part of this ordinance as well, possession and or manufacturing. So this ordinance would touch the individuals if you could find out who was actually doing the milling. Yes.
Okay.
Thank you. Are you finished, Member Brooks?
My other question, would it also go outside of Philadelphia lines? So if we were to determine that the milling was happening outside of Philadelphia, this jurisdiction is only within Philadelphia, not the surrounding counties. Am I correct?
That is correct.
Thank you.
Good questions, Member Brooks. Member Johnson?
Yeah, I just had one question for Chief Inspector Healy. Do we know, out of the guns recovered, how many were used in homicides, how many were used in shootings, how many were used in robberies, etc.?
That I took a note of that from your earlier comment. I'll reach out to Director Garvey of the, 168. I'll try to get a breakdown of what they were associated with specifically. I don't have it with me now, but I'll see what he can do to get there.
Member Johnson.
Thank you. Thank you very much.
All right. Are there any other questions?
No other questions in the chat, Councilman.
Seeing none. Are there any other witnesses to testify on this bill?
No, there are not.
Are there any other witnesses not registered that wish to testify on this bill? Hearing none. This concludes our hearing, and we will now go into our public meeting. I want to thank all those who testified as they disconnect, and thank them very much for their important testimony on these two bills. We'll allow them a moment to disconnect the witnesses. And we will now transition into our public meeting. Ms. Williams, can you please call the roll to determine we still have a quorum?
Yes. Councilmember Thomas,
Present.
Councilmember Green,
Present.
Councilmember Gaudier. Present. Councilmember Gim,
Present.
Councilmember Brooks,
Present.
Vice Chair Johnson,
Present.
and Chairman Jones.
Present. A quorum has been established for our public meeting on bills number 200479 and bill number 200593. All right, and we have a quorum, and so I will recognize my Vice Chair Johnson for a motion on bill number 200593.
Thank you, Mr. Chairman. I offer amendments to bill number 200593. A copy of the amendments have been circulated to all members of the committee. I move that the amendments of this bill be approved.
Is there a second?
Second. Councilmember Green.
All right, it has been moved and properly second that amendments to bill number 200479 and 200593 be approved. All those in favor will signify by saying aye.
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 All those opposed? The ayes have it.
Mr.
Councilmember, Vice Chairman,
I caught it.
sorry.
And so, Mr. Chairman, I have to go back and offer amendment for bill number 200479. Is that okay? To correct
That
the
is fine
record?
with me, sir.
Mr. Chairman, I offer amendment to bill number 200479. A copy of this amendment has been circulated to all members of the committee. I move that the amendment to this bill be approved.
All those in favor say aye.
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 All those opposed? The ayes have it. Chair again recognizes Councilman Johnson.
Thank you, Mr. Chairman. I now move that bill number 200479 as amended be reported from this committee with a favorable recommendation, and further move that the rules of council be suspended to permit first reading of this bill at the next session of council.
Second.
It has been moved and seconded that these bills as amended be approved. All those in favor signify by saying aye.
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 All those opposed? The ayes have it. And bills number 200479 and bills number 200593 have been approved.
Chairman Jones, I think there was a second part of the amendment for a rule suspension. I mean, a second part of the motion for a rule suspension.
Okay. Let me go back and say that there was a motion and it was approved for bills number 200497 and 200593 be approved by this committee with a favorable recommendation, and that the rules of council be suspended to allow first reading at our next session of council. Correct? Is that we're calling for the motion? Or was that approved? You got me confused.
I think it needs to be seconded and voted on.
Second.
Second.
All right. All those in favor signify by saying aye.
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 All right, it has been approved, and bills number 200479 and 200593 have been approved. And with that, that concludes the business of the Committee on Public Safety. Thank you for your participation, and have a great day.
Thank you.
Thank you.
You're welcome.
Have a great day, everyone.